guess it's 2 o'clock now, so we're going to get started. So, hi and welcome. Thanks for coming today. Before we do get started, we have to mention a couple of things, and that is please silence all electronic devices. There are plenty of open seats up front, and this session is being recorded. And then for our panel, actually, I had a couple of things I wanted to say before we got started. I just wanted to share a little background on how this session came to be, because it was a bigger group discussion at the state level that provided the original impetus for today. So within the state university system of Florida, the e-resources librarians from the 12 universities meet monthly. Earlier this year, Athena Hepner at University of Central Florida emailed that group to ask about contract review and procurement processes at our respective institutions, specifically because UCF was implementing a new contract routing and certification form. From the responses to Athena's email, it became clear that a lot of us have been experiencing an increase in rules, regulations, and general bureaucracy surrounding the licensing and invoicing of electronic resources. A lot of our institutions have adopted new procurement workflows and implemented some sort of online contracting system. And the discussion that continued in the following meeting of those e-resources librarians, I said something like, and this is a paraphrase, I wonder if our vendors know about all the bureaucracy we're working around. And Aaron Gallagher at University of Florida replied something like, that'd be a really good discussion for Charleston. So here we are. Second, we did want to mention that we've structured today's session in a way to encourage collegial dialogue. We've prepared a few questions for the panel discussion, after which we'll ask for audience participation. While there may be no solid resolutions today, our hope is to build better understanding, so we might approach future negotiation discussions with a little more grace. We intend to keep examples intentionally broad, so they have applicability for a lot of people, hopefully everyone, and we hope it'll set the tone for our larger group discussion at the end. All right, so who are we? Ken DiFiore.
Good afternoon.
Right.
Hi, I'm Ken. I am with Library Outreach Director for ITHAKA. And in fact, this month I'm celebrating my 15th anniversary. Actually, thank you, Elizabeth. I put that slide up there because ITHAKA is the organizational home for a number of different services that I suspect all of you are familiar with, but not quite sure of how all are organized. So ITHAKA is the umbrella, and then the services are JSTOR and Portico and Art Store, and there's a strategy and research group. So I wear that library outreach hat across all those services.
All right, Rachel Erb.
Hi, everyone. I'm Rachel Erb. I'm the Director of Electronic Resources at the Florida Academic Library Services Cooperative. And I've only been with FALSI for about a year and a half, and prior to that, I was the Electronic Resources Management Librarian at Colorado State University for 7 years. And a couple of things I want to mention about my organization, it'll be within the context of what I'm presenting, is that we currently fund a statewide collection on behalf of our 40 member institutions. We serve 12 state universities and 28 state colleges. That statewide collection is valued at $6.8 million. We also oversee our opt-in process. As of last year, that was a $1.9 million worth of business.
Next up is Erik Circle.
Hello, my name is Erik Circle. I work for Sage Publishing, and I have been there for just over 7 years as of October 1st. And I've had a couple different roles within Sage. Started as retention, working with renewals and processing orders, helping our customers. I then stepped into a role that supports our sales team as well, and managed a team that supports our sales team. And then a little over 2 years ago, began helping out with the licensing process, and have now taken that fully on.
And I'm Elizabeth Lightfoot. I am the e-resources librarian at Florida International University, and I can never resist including a picture of the lovely green library with palm trees. One of my primary responsibilities is negotiating license agreements for the library, as well as coordinating the content of our e-acquisitions. Yes. If you're not familiar with FIU, we're the only public research university in Miami, and we're a very large R1 majority-minority doctoral institution with a student headcount of roughly 58,000. We do have one other presenter who was unfortunately unable to join us today, but we wanted to acknowledge Valerie Boulos from Florida State University. She was unable to make it to Charleston due to a death in the family. But Valerie worked with us to prepare this session, and we wanted to keep her in here because a lot of these ideas are hers. All right, so with not very much ceremony, we're gonna launch into questions and just kind of go for it. So what are you seeing publishers or libraries do that helps the licensing process? And conversely, what are you seeing publishers and libraries do that makes the licensing process more difficult for your organization? Okay, so I was one of the people, moderator jumping in. So some of the helpful things that we see are frequent or quick communication when we're kind of in the throes of negotiation. I always appreciate a willingness to even entertain negotiation. I've been encountering more and more situations where there's sometimes an outright refusal to even begin negotiations. So even in cases like that, I also appreciate the ability to explain the can-nots versus the will-nots, like what's not acceptable. I'm going to continue with challenges if no one's going to jump in. Okay, so part of that is the refusal to negotiate boilerplate terms and conditions. It's very difficult for us as a state agency, and we have to comply with the state law of Florida to not be able to negotiate some of those terms. Another big one that we're seeing is starting from scratch every single year. So you've spent a really good amount of quality time, in your opinion, working through a license agreement, and you're really proud of it. And the very next year with the renewal, you have to start from scratch with the boilerplate terms and conditions anew. It's very difficult and time-consuming. Another thing for us is become increasingly difficult is the actual signature process. In the past, our dean was able to just sign things, and we've moved to an online contracting system that requires approval from multiple departments within the university, outside of the library. I'm gonna step away and let other people jump in.
Okay, so I'll chime in with the first part about helpful. So what I've noticed that I find that's very, very helpful, and I should have mentioned this earlier, that I do handle the negotiations for the contracts. So what I really appreciate is after I've done my initial redlining and I respond to the vendor, and then he or she shepherds that on to their general counsel, is that in their response, which of course we've all agreed to use track changes, that general counsel is copied on that initial, on their response. That helps link us to that general counsel who's working on the agreement on their behalf quicker. And I find that when that happens, I've noticed that the contract is executed a lot sooner. I don't know why that is, but that's just something I've noticed. I also appreciate, of course, anything like a quick turnaround. And if there is an issue with a turnaround being delayed, being notified as to why, instead of, I'm kind of a stickler for using my Trello board for follow-ups. And there are some vendors, I'm not kidding, I have about like 12 follow-ups before I get an answer. Whereas, our general counsel has left and we're having an issue right now. We're searching for a new general counsel. This actually happened last year with one publisher. So knowing what's going on and why the contracts are being delayed is really important. That helps us stay on top of things, because we also have our own internal deadlines. Again, with more of the difficulties I've noticed is that what you have to do, I think, is have a pre-agreement for the negotiation process. So what I mean by this is you have to agree up front. Are we going to agree to use track changes in Word? And are we going to agree to consistently use track changes in Word? What I have found is that you may use track changes, However, they'll respond in a PDF, and actually there's something sitting in my email as we speak that is a response in that manner. And it's the same issue we had last year. So it's those kinds of things. So you definitely want to make sure you're all on the same page as far as the procedural aspects of the contract process. Let's see what else. Another thing I noticed, and then this is my last point, has to do with the terms and conditions. And I'm really a stickler about contract language. I think it's because I have a linguistics background, and for some reason it speaks to me, is that indemnity clauses. We're all familiar with indemnity clauses. Do I need to explain briefly what that is? We're good? Okay. Mm-hmm. So it is, essentially the responsibility of the parties regardless of who is at fault, and you have to make that agreement on who's going to be the responsible party in the agreement. Of course, what we strive for is that the licensor will indemnify the licensee. However, we all know that in most boilerplate agreements, it's going to be the converse of that, where the licensee will have to indemnify the licensor. In most states, you cannot agree to this. At least the states that I've lived in where I've handled agreements, that so far has been Nebraska, Colorado, and Florida. What is interesting about indemnification versus hold harmless is that sometimes you will see both terms used in an agreement. However, Ken Adams, who I'm a huge fan of, by the way, and he's written the style manual for contract drafting, makes that distinction. These are two, they are different. So for example, hold harmless is understood to protect against the risk of a loss as well as the actual loss. Indemnify can also mean to reimburse for any damage. Essentially, that is a narrower meaning of hold harmless. So it's those kinds of things you'll see them conflated, you'll see them used together in these boilerplate agreements. And of course, this has been going on for as long as I've been handling contracts, which I think now has been almost a decade, that this still hasn't changed.
Thank you. Yeah, just a quick comment from the vendor side for me is and that's one of the reasons in that intro slide, I showed the ITHAKA as the organizational home for those services, because it's really an amalgamation. So libraries are licensing these individual services, and so what we've tried to do is implement some back office systems that can really facilitate that, and with the overall goal of simplifying it. Maybe we can have a common license that spread across, say, Art Store and JSTOR, for example. It's not always easy due to the intellectual property rights, but that's what we're trying to do at our end. And one of the things that I'd say that was a little bit of a chuckle when we were having our planning sessions here. Elizabeth and I were chatting that, the best intentions don't always come to fruition. When your organization implements some of these back office systems and new workflows with the goal of making things a bit more efficient, sometimes it can actually not be as efficient when you're in the field. You would think, why are we doing this? And then you talk to a librarian customer that you say, gee, can you fill out this form or that form so we can expedite the licensing process? And they look at you like, well, we can't do that. And so, it's a moving ball. We're trying to improve things. It's not always a straight path.
Something that we've been working towards for the last few years, I'm not sure if I'm too close or close enough, but is working towards getting a master agreement where we can have all of the terms and conditions in one single agreement, so that future orders would just be amending an already agreed upon terms and conditions. We've received a lot of feedback from our customers, and some customers just not even purchase anything, just want to move towards that as well. It makes the future purchasing a lot easier. We've found that some institutions, some that even have the signing power, the librarian themselves, are able to turn that around, because the future purchase is just a single exhibit that identifies just what the sales details are and doesn't necessarily go all over, starting all over from your example. A challenge that, it's interesting that Rachel mentions the boilerplate, because we get those too from our customers that need specific terms and conditions in the agreement. The challenge that we have is when there are no negotiations at all. And this is applying to all sorts of different products that they're purchasing. So then now we're coming up with challenges because it doesn't apply to the product. And so it's being asked for Sage to sign something that doesn't quite apply. So we do have some challenges with that as well. So it's interesting to hear the other point of view as well. Yeah, of course.
So I have something to add about that. I think what I failed to mention earlier, and I think this is really important, is that FALSI is under the auspices of the University of West Florida. So what I mean by that is that we use their general counsel to work with our contracts. And we include an addendum that is essentially, several different types of, clauses that frankly don't have any cohesion. It can be anything from the indemnification clause that we include in the agreement where the vendor will indemnify us. And it can include HIPAA laws, FERPA, and things like that. So it's really just kind of a very strange beast that we have to include in our agreements. One of the things that we have to look out for, of course, is to make sure that what we have in that addendum isn't duplicated in the actual master agreement. But my point about the vendors is that I am not permitted to edit that at all. I have to work with our general counsel. So I definitely see how there can be some problematic terms for our vendors when we're negotiating about that amendment. The other thing that I've noticed, and this is something that we've had to be very transparent about early on, is that if there's a conflict between the agreement and that addendum, the addendum controls the agreement. So that is something that, we need to make sure up front that that's the case. So those are some things that we deal with on our end. So essentially, it's not a master terms and condition that we present to the vendors, but it certainly reads like one, I think, in many ways.
So alternately, at FIU, I sometimes have a tiny bit of wiggle room with those things that are required by general counsel. If I can go to general counsel and try to explain to them that this doesn't apply and reassure them that a publisher isn't going to have access to university credit card information or student grades or anything like that, they can kind of work with me. At the same time, that is kind of a double-edged sword, I guess, because master agreements, we in the library like them because we can kind of, it's like the mega agreement to rule them all. And it makes purchasing things easier, and it makes end of year kind of a breeze when you're looking for fiscal year items. However, our general counsel really pushes us to strike anything that doesn't immediately apply. So it's like if there's reference works that we might someday buy, but we're not currently buying them with the contract that's going through with the current purchase, I have to ask to strike that, and it makes me a little sad. But we come up with ways to kind of make schedules or refer to like other schedules can be added or amendments may be added for purchase. So, all right, are we ready for the next question? That's nicely about master agreements. All right, what are the pros and cons of receiving an amendment or new agreement versus an order form? Corollary, once the master agreement is signed, would obtaining a signature be easier if the new sale was titled Sales Details rather than Amendment? I guess I'll jump in. So I joked when we were preparing that my answer was no. So I kind of mentioned it, and I will probably mention it a few more times. About 2 years ago, FIU adopted an online contracting system. And even though our dean retains signatory authority up to a certain amount, and we can sign in-house, if you will, going through this online contracting system that's mandatory and supposed to it's for accountability and transparency, and I understand. It adds a lot of work for everyone else that's outside of the controller's office. And so putting anything in here, even if it's in-house, means that it will be seen by the purchasing department at least 3 times throughout the way. It gets approved by general counsel, who has minimum 2 weeks to approve and look at things. And depending on how we enter the contract and what kind of contract it is, it might also be seen by the university IT department, tax compliance, external relations, Office of Research and Economic Development. There's a whole list of things depending on how we answer a questionnaire of who will see this contract and who does Elizabeth need to bug along the approval workflow. All that is my way of saying that even if we sign a master, no matter what the form, the renewal form or additional purchase form is called, if it requires a signature, that whole master agreement will be reviewed again. Even though the university has already approved it, I have to append the new thing and write a huge kind of executive memo saying, you've already vetted this, like you've already approved this, please approve. It can still take 6 to 8 weeks to get that same master approved in theory, even though they're just doing the sales detail or the amendment. So that sounds a little scary. I hope it wasn't. Yeah.
I can continue.
Yeah.
Okay, so for our situation, it's very similar. Just because we have a master agreement signed, you would think, oh, well, you can just easily sign the order form and call it good, and then pay your invoice and all that fun stuff. Well, that's not really the case. So in the year and a half that I've been with Falsey, there has been a change, and the change started last winter. Whereas now I am not permitted to sign an order form. The order form must go through the Office of General Counsel at University of West Florida. This means not only does the Office of General Counsel have to review and sign, but also in many instances, the president of the University of West Florida must sign. This can take a while. The other issue is that you would think with an amendment, yes, sometimes you do have to make some cosmetic editorial changes to an amendment, that an order form should be simplified in the sense that you don't have to edit. Not so. There was one order form from one particular publisher last year that did require a bit of a change in the language in the order form that was flagged by the Office of General Counsel. So in an ideal world, it would just be very simple that you just sign an order form and that's it. But that's not the case. The other thing that we run into, now keep in mind, so we've got these master terms and conditions, and we may have one of our member institutions through our opt-in process subscribe to a particular resource that's going to require an amendment. That amendment not only must be signed by Falsey, University of West Florida, but also their institution, so it binds them to the agreement. So again, that takes a lot of maneuvering and can take several weeks to formally execute.
Just a quick comment from us, because a couple of years ago we implemented an order form. We thought that was was hoping to simplify the process, right? So when a library wants a new JSTOR collection or art store some new bit of content, the agreement was already in place, and we thought, okay, we'll just send out an order form, get a quick signature. It's essentially just, hey, we want this. But as you heard,
it makes sense.
It does make sense. But as you heard, you can often get, I know what I get is I can't sign anything. It has to go to legal counsel. The whole contract needs to be reviewed again. And so, pros and cons, good and bad.
One thing I will add, and this is about my past life, is that it was very simple. So we would have an order form. Of course, we had the master terms and conditions. This order form only needed to be signed by one of our assistant or associate deans, who is also controller designate, and then we could just send them the order form within the 3-day turnaround and then call for the invoice. So yes, I think it definitely varies by institution. I also wonder if it varies by state.
I know it varies by institution, for sure. I was just remembered, I know when we were preparing, and I'm going to misspeak, and I know there's some FSU people in this audience, so I won't put you on the spot. But I think Valerie mentioned that they had a little bit more nuanced process, and that they were able to kind of sometimes sign things that were a specific, I'm looking at you. I'm looking. That if it is a sales details, there's certain situations where they are able to sign. And they're one of our sister universities in the same system. And we just have very different process. So.
I think there's a question.
Oh, yeah. So the question is feedback about an auto renew with very specific cancellation terms.
I think we talked about that, didn't we, about renewal agreements and?
Yeah, we talk a little bit about renewal agreements. I know for us, this is going to be an anticlimactic answer. We're unable to accept any auto renew. We just can't do it. That's actually a deal breaker for us. So I haven't had to deal with any of that. I don't know if anybody else, or yeah, Eric or Rachel.
Yeah.
Okay.
Go ahead.
So
Okay.
Eric, you want to go first? Okay.
We have a couple products that are auto renew, and kind of going back to a couple of comments that have been made earlier is the track changes, just making sure that there's openness for being able to negotiate that license. I'm not sure if you're speaking towards feedback as far as how to get that license through your system, or if it's just more about a product that is auto renew that's kind of challenging. But one of the things, we just make sure that that license is clear, so that if someone does not want to renew that subscription the following year, they're able to. But we've also found that it's been helpful for some of our institutions as well, because they do not have to do a license every single year, which has been helpful for them as well.
Yeah, I think for us, it was standard practice, the auto renew. And then I guess 5, 6 years ago, maybe, we started to hear from libraries that there's been changes in the state laws, and the institution would say, we can't do that anymore. We can't, evergreen licenses. And so we've had to adjust to that and accommodate that, and it takes some internal resources to do that. That I think helped drive the implementation of some of these back office systems I opened with. So legal can look and look to see whose agreements need to be, don't auto renew or couldn't agree to that. So then those will get kicked out, and someone like me will get called, and you'll have to address that.
Okay, this is a very interesting question for me, because I went from an institution that highly encouraged auto renewals, and of course we had an exit out clause, and it made my life a lot easier as the sole person handling contracts at an ARL. And then I come to this environment, and that's not the case, that we're not permitted either through the University of West Florida to agree to any auto renewals. However, we do have a couple of workarounds. One being that we can agree to language that might say the agreement will renew for one successive term, and that's it. So that at least gets you out of the having to handle, a contract negotiation again for another year. So you buy some time in that regard, and that has been permitted by our Office of General Counsel. And of course, the master terms and conditions are valid for approximately 5 years or so, and we don't really have like a firm guideline on that. It's whenever procurement decides to flag it and say this needs to be redone, and then we can usually buy a time for a year, and then we have to redo it. So those are some of the workarounds that we've implemented.
Yeah, one thing I failed to mention, I think that we've seen that's linked with that is the confirmation or verification of fees. So in addition to, the license part, the institution will say, okay, what's my fees going to be? And I think there's that just very strong interest on behalf of the institution to make sure they're not signing up something long-term that locks them in some successive fee increases year over year as well.
That reminded me, we have a standard supplemental addendum that we work to append to every agreement. And it just generally allows us to comply with the state laws of Florida and protect the university. But I'm going to forget the exact language, but one of the provisions in there, it says no auto renew explicitly, but then it details basically if the university asks for an invoice and pays you, it's considered renewed. So that's kind of the how we might get around it. We haven't signed anything. If I've emailed you and said, hey, can I give you some money so that we can have another year of access? Renewed. But we're not allowed to auto renew. So it's, I guess we're calling it something different. Oh, yeah.
I have a
Okay, so I'm going to try to repeat that in case people didn't hear, and I'm going to get it wrong. Sorry, Laura. So, with regard to the once a master is signed, what's the ideal scenario or situation for making a new purchase off of that master or an addendum to not have a signature? If it's a totally new product, I assume we would probably want a signature. And I know, like, I'm saying conflicting things, so that 2 years ago, that darn contracting system we implemented, we're still figuring out institutionally, I think, how to handle things. The library had kind of a grace year where we could still sign in-house. Like, literally, I would walk it down the hallway to the dean and have her sign, and then I would scan it and send it to the vendor. That has changed a little bit. So we're figuring it out on our end, but I'm sure other people might have ideas or have already solved this and you're light years ahead of us, so feel free to share. Or you can save it till later if you're shy.
I don't know, Elizabeth, it feels like it might lead into the T's and C's question.
Sure.
I don't want to, jump over our plans, but that's
Okay.
a great question. I think, so from our perspective, what we tried to do is, and Elizabeth touched on this a moment ago, was, and it doesn't always work, is we implemented the T's and C's on the website, and it specified, say, all the content products that it would cover. So even if the institution didn't have those at that particular moment in time, it would cover those. And then if they added it later, there wouldn't have to be a whole new negotiation again. So if they picked up that new product, like say they had a JSTOR journal product, the T's and C's would include the books, T's and C's, the book, the legal aspects, the terms around the books, and then if they added it later, that would be okay. They could just say sign the order form because the T's and C's would already be in place.
Okay. You skipped ahead a couple questions. Yeah. Okay. All right. We'll move on to the next question. So what are some of the common items and licenses that slow down the process for your institution or organization? I realize this question was a little library specific. So we have the usual suspects. We're a state agency, so it's governing law and jurisdiction, confidentiality, that kind of thing. Some unexpected things for us maybe, and this might be more procedural constraints, I guess, than the actual license terms. It's odd things that have been surprising me. So company and product name changes throughout the years. So every time I submit a contract, I have to submit the previous year's contracts with it so that they can review what we've done. If a company changes names even just a little bit, or they call something different, or the database has a new name, they'll say, this is an entirely new product, we need to review it. Are you sure this isn't a software license that's gonna infect our computers? It's very difficult for general counsel and procurement to understand kind of, I think, the library marketplace. Though I imagine I shouldn't say regular, the regular marketplace they're dealing with in the business world, contract world, is probably not that much different, but the mergers and name changes throw everyone off. For us, and that's kind of, Ken mentioned it, and I think it's in our next slide as well, linking out to anything is really frowned upon. And that's not necessarily a term, but anytime there's a URL in a contract, I just dread it because I know that I have to say, okay, I have to go to this page and then this page, and I feel like that scene in Parks and Rec when he did anyone, that Grizzle scene when it's like, I didn't notice it because it was the day Star Wars was released. And it's like the 500-page agreement. But I have to go through and print them out and append them to the contract, and we have to say that these terms are applicable to our users at the time this page was printed out, and here they are at the end of the contract. But we'll talk more about that on the next slide. So yeah, go for it.
Okay. So first I'll talk a little bit about the license review process as a whole, and that's your initial reading and redlining of the agreement. what I've noticed, whoops, sorry, my little computer here, over the past several years is that certain problematic terms are a lot more buried within the agreement. So for example, you'll see limitation of liability clauses, which is sometimes referred to simply as a liability clause. It's the section of the agreement that specifies the damages that one party will be obligated to provide under the terms and conditions stipulated in the contract. And I feel like it used to be more overtly expressed in the agreements, and over time I realized that's not really the case, and sometimes I didn't catch it, our general counsel would. And there are other, things like indemnity and some other, problematic terms, jurisdiction, that are, similar in that regard. One of the things that we've done this year is we are currently piloting legal review software that's powered by artificial intelligence. It's called Legal Sifter. We are their first library contract. And what we've done is we are using, what happens is you upload the agreement, it'll sift through the agreement, it'll pick out the terms, and it'll also provide language that you would like to include. You can use their boilerplate language, you can add your own, so you have the administrative capability of doing so. And I have found that with some of the more, any agreement over 2 pages, it really cuts down the review time in half. Certainly, you still have to go in and you have to do the redlining, but at least you can see, you can export it into Word, and it has the comments that flags all the different terms and recommended language and so on, and things to review. And it's been really incredibly helpful for us, because we do handle quite a few contracts, and it's not only one person handling them. So some of the other things that slow down the process for us actually have to do with procurement and their ever-changing requirements for an agreement. So for example, about 2 weeks ago, I found out from our general counsel, or contracts administrator, who liaises with general counsel, that VPATs are now required for procurement for any new contracts. So I have to ask for that in addition to the other, the contract and things like that. The other thing I've noticed new this year is that our procurement, and this is very interesting because we negotiate agreements on behalf of our members that are spent with their local budgets, that our procurement officer still wants to see what the amounts are going to be for those institutions, even though we're not funding it. Another feature, and this is new also this year, is that our procurement officer likes to see title agreements for e-journal contracts, title lists. So I also have to include the title list. So it's also the pricing information for each participant, a title list, and a VPAT in addition to the contract, in addition to last year's contract, or the year, the current contract. Another thing I noticed, and this was soon after I arrived, is that any agreements that FALSI has with another consortium, such as Lyrasis, even with our centrally funded collections, that we have to prove how our membership to Lyrasis, for example. So in the past, I think it was kind of accepted and it was fine, but now we have to also provide that documentation. So it's definitely more legwork on our end, in addition to the complicated contract review process.
One of the things that can kind of slow down the process, at least on our side, is just going back to communication. So if there are changes in the license that come back to us, is just understanding why they've been changed, because it could just be, versus the differences between the will nots and can nots, or should nots. Mm-hmm. Just being clear with what it is that, I guess, what the customer's trying to get at.
Yeah, I've been guilty of that. the absolutely cannots versus the simply will nots. Oftentimes I feel, and maybe a lot of us are like this or feel like this, we're kind of in the middle and communicating directives from different stakeholders at our institutions or organizations. So when my general counsel says, oh no, you can absolutely not accept this limitation of liability, there's no way. They're not capping liability. So I always push hard. When someone pushes back, which happened a couple years ago, or maybe just last year, the year before, I go back to general counsel, see what we can do, and hear, oh, well, it's state law, so we don't like to kind of limit our ability based on state law. We want to take the full extent of the law and what's allowed to us. However, if it's really a deal breaker, we're fine with it. So that's okay. In this case, do you feel comfortable with it? Have you assessed the risk? Which that was on me, because for 3 years I was pushing hard on this liability, and now I know, okay, I can make these risk assessments or see if my dean is comfortable. But that's just our specific situation, and that kind of goes to maybe communication, which we're going to talk about in a little bit. So this one, we've kind of mentioned this one a few times. The website terms and conditions. Do vendors really need them, and can libraries really agree to them? And so, I know we talked about this.
Yeah, I'll jump back in on this one. We're a relatively small nonprofit with thousands of customers around the world, and so it's very difficult to manage try to manage all the different variations of T's and C's over the years. So what we've done is we've put them up on the website, and as Elizabeth said, she cringes when she sees URLs, but that's what we do.
I understand why they're there, and
Yeah.
they could be really good.
Right. So, but and with that, as she's mentioned, there could be issues, and so we know it can it can prompt a scenario where they're actually printed off by the library that we're negotiating with, and then the edit process could begin at that point. But what we found overall, that really is the most efficient way that we can implement T's and C's on a global basis.
We use an order form for some of our products, and on that order form, it links out to the platform and just goes over the access terms on the platform. We could also just do an actual agreement as well. I've had some customers that have requested to take all of the access terms that are on that platform and put it into the order form, which kind of makes it a little bit longer. Or we could use an amendment as well. No, it's really whatever. It kind of goes back to the communication. If that's something that you can't sign, just let us know so that we can approach that and either put it into an agreement or expand the order form. Yeah, we found that it's been helpful for some customers. It just goes straight through their system. So just making sure that communication's back and forth.
And I'll say that in the event that what Erik just presented is not an option, what I did is I printed out the T's and C's and saved it as a PDF and ran it through Legal Sifter and then just treated it as it essentially is the agreement, and it was a situation where it was an order form and then this link to the T's and C's, and I just treated it as part of the contract, which it is, and then just did my review from there.
Elizabeth, I didn't mean to go off script, but I'd be interested in what folks, in the audience have any thoughts on that. How do they feel about that?
Well, I see
Anyone
a hand
wanna-
up way far in the back. There's a microphone up here, unless you really want to shout. I'm so sorry.
So I've been grappling a little bit with that link out thing too. One of them was a JSTOR license. The question being, if we sign that, am I signing an agreement to the terms and conditions at the moment that it's signed, or can the vendor change those terms and conditions at will, and I have agreed to whatever changes they are without ever seeing them, which is not really okay and not reasonable. So, but often that's sort of what's implied. The reason you've got a link here is because we're trying to manage all this stuff and we may have to change it, but then I haven't had a chance to see those changes or agree to them but it's already been signed.
Yeah, you not only asked the question, you answered it.
Right, right.
So,
It's sort
yeah,
of a
that's why
problem. It
we
doesn't,
do
it should say explicitly somewhere in that link text, this text is as of the date that you signed the agreement. Or it's going to have to say, you're agreeing to changes without seeing them,
Yeah.
which everybody's going to reject.
Right, right. And part of that, so you understand where, again, the impetus is efficiency, but also, and I don't know who mentioned it, maybe it was Elizabeth, about the different content types. So we if we add a new collection or content type, we just want to make that adjustment on the T's and C's without having to go back and renegotiate things, because it's really, in essence, going journals or books, or we have things called thematic collections that have some data sets, and so we'll just want to adjust the T's and C's like that, and hopefully that isn't a big deal. But as that question comment implied, it can be a big deal for libraries because they have agreed to something at a point in time. So. And that's where we have to go through the process of, we heard of printing those out and, including them as part of the order form and whatnot.
Sometimes what you'll see in the main agreement, if it has a link out to additional terms and conditions, is that the publisher will mention that these, before you preface it for the links, that these are subject to change without any notification, and then you negotiate that out. That does offer, that additional layer of protection. I think there's a question.
Yeah, we do put that clause in there, though, that if the change, if the library isn't happy with the change, of course they can renegotiate or they can withdraw from participation in a collection.
Hi.
Hi. I work in a law library, so my situation might be somewhat different. And my understanding is that at law libraries, negotiation is not as hard as in the main libraries. That's what my understanding is. And I'm seeing more and more these website terms and condition link in the order form. And so many of those terms apply to like individual subscribers. And generally, I have seen that publishers really push back that, oh, we don't want to change for each and every one. And they really will try to push as much as possible. And especially if the renewal time is coming close. And as earlier somebody mentioned that, especially the clause that we can make changes anytime, and if you continue to use this website, you are agreeing to the terms and conditions. So are there like, it's just for convenience, or they don't give another contract to us, it's just that, and then we try to negotiate from that, which is not as good as maybe starting a proper license. So could you suggest whether we should ask for like a proper license that way, rather than amending to those ones on the website? And we again do the same thing if we do settle, we print it out and definitely change the term that
Right.
we won't agree to, change any time.
Yeah, right. That's
Thank you.
Yeah, that's the common approach that most folks take. And I'd be interested if this is applicable to your respective situations. Is we'll get almost like a state T's and C's. So every contract that the library, the institution which the library operates, it's a state institution. They have a list of their own kind of T's and C's, and so. They might actually link to their own state website or hand, and then we have to download that and turn it into a PDF and have legal counsel edit it. So, it's not just the vendors that are doing web-based T's and C's. These state institutions that are, or the states that are governing the state institutions use that approach as well.
And generally, do most libraries amend the publisher's contract, or do you give yours contract to publisher and let them amend it?
It's sort of a meeting in the middle. We put our materials forward, our license materials forward, and then we'll get, suggested changes, which will include the state's T's and C's, which then we'll forward to legal. I suspect you're probably saying.
Yeah, we generally use our contracts because it already covers all of the product. It talks about whether it's perpetual, whether it's lease. It covers term dates and everything. We're open to receive, just like Ken mentioned, our customer's agreement because there's specific things that need to be in there. So that is one thing that can kind of slow down the process. Just to be clear, because I have to work with a team that understands the accessibility aspect. If there's accessibility in there. So just making sure that I work with a bunch of different people that understand that legal terms as well.
Yeah, and I think connected with all this, and I know we've said it, and this is, I'd say, a big takeaway is communication. So when you're from past acquisitions that your state does this and has these forms, get those over to your vendor reps as soon as you can. If there's nothing, well, I don't want to, play it up too big, but when you're in you think you've got everything taken care of, and then you get sort of hit with this, like, here's our state requirements. It's got to go to our council, and you're almost back to square one again. So that communication is such a big thing between you and your vendor rep, and vice versa.
Sorry, I don't want to take too much time, but one last question. I feel that if there were an academic license, it will be so much better instead of, because individual libraries negotiate on so many terms, which I feel like most of the library academic institutions do. So wouldn't it be better if publishers have those kind of licenses at least to start with, so that we don't have to start, from the beginning every single thing?
Well, I think
Which is-
we
At least
base
in
our
legal word, I have
things on a
seen
model
sometimes They are
license.
so one-sided. I can't tell you. I know about legal word mostly, not general. So
Right.
they are so one-sided. They know that people, but probably some people don't. So they think that maybe whatever So I tell them that why don't you send me some educational or institutional license if you have one, because that will be much more geared towards us rather than law firms.
Mhm.
Because law firms have a very different kind of a need and protection and all those things, while educational institutions are
Different, yeah.
So I
That's a good
just-
takeaway. We don't have a separate one for law firms. I don't know if you guys do.
No, it's product specific.
Okay. Another question. Yes.
Yeah, I just remembered a couple of years ago, I heard about this Zero initiative from, and I just wondered whether you guys could comment on that. It's the shared electronic
Resource understanding.
or
So
something.
I can. It's a great idea, and my institution would not let us use it. I was like, I have this great solution for you, General Counsel. No.
But it's just
Yeah.
because this is very sort of library sort of centric.
Yeah.
But from a vendor perspective, I was on a call with some consortia, and one of the bigger publishers said they had 7 people in the U.S. alone just reviewing contracts, and they said, how many people have we ever sued?
Yeah.
Zero.
Yeah.
And how many times have a library had to pull out the contract and beat the publisher over the head with it? I don't know. It just seems like a tremendous amount of work for something that really isn't that relevant.
Yeah, I'm not going to touch that one because our legal counsel, because I've actually used that internally, and they're like, you're not a lawyer, so I'm not going to touch that. But going back to the model licenses, yeah, we try to do that. The thing, it's funny, I'm a former librarian, and I've been on the business side for some time now, but when we say model license, or because there was at CERU, there's a neural model license for the Northeast libraries. The consortia have different model license. So we do bring all those things to legal and try to normalize it, if you will, and include the clauses. But there's going to always be some differences. But that's a great point.
So in my current environment, I'm not permitted to use CERU, but in my past life, I was. And so I had better luck with smaller vendors and publishers to use it. So whenever I could, use it, I would. And I had the blessing of our general counsel, and it did make our lives a lot easier.
Okay, we have, I think, just 2 more questions, but we're running closer to time and wanted to hear from more of you, if you feel like sharing. Sure, come on with your question. Our next question actually, and if the audience wants to answer this question or the next one, I don't want to put anyone on the spot. Do you have a clear communication path at your institution for licensing?
Hi, William O'Connor with IEEE. Comments, questions, everything. Rachel, you had mentioned up front about you'd like to see when a general counsel is engaged early, like by copy. Just as an FYI, because attorneys ethically can't negotiate with somebody who's not an attorney, our attorneys specifically tell us that unless the other people's attorney is engaged in the emails, not to engage ours also, even though they're involved in it behind the scenes. So that's just an FYI. You also talked about mutual or indemnification. Are you okay with mutual indemnification?
It depends. Again, this is
Well, thank
what
you
our
for that,
general
but-
counsel. Our general counsel has the final say on that. And there was a situation where, after many, many months, they did agree. Well, our general counsel agreed to hold harmless, and that was a compromise.
Okay, and then for Rachel and actually also for Elizabeth, we talked about linking out, which we generally don't do. Our terms and conditions, we actually roll those over year to year, and then like every 5 years, we'll have you sign a new one just in case there's changes in it. But certain things we do link to, like our privacy policy, because that is maybe subject to change. Do you think your attorneys have problems with that kind of linking out?
Be honest.
I guess it depends. It really depends on what information is being collected. I guess they're worried about user privacy. It's case by case. I know that sounds kind of crazy.
Okay, great, thank you.
Yeah.
The one thing I will add about the general counsel is that when I do send out my initial redlining, most of the time I do copy our general counsel, so he is included. So that, I don't know if that makes a difference or not, but that's just been my standard
Yeah, our
practice.
attorney will, again, just because they don't want to possibly get into negotiations if they're not supposed to. But if yours is CC'd, then we can certainly bring ours into it as well. Thank you.
And I'll jump in and say, for my institution, we can absolutely accept mutual indemnification as long as we reference the specific state statute that talks to indemnification. So, yeah. Oh, great.
I wanted to refer back to something that Rachel said about VPATs and procurement. At my institution right now, we are backed up all the way back to July for our contracts because the accessibility language is not at a 2.0 standard. And I'm just curious how many other places are struggling with this. It's our licensed people that are having to make those changes and deal with it, although I realize it's procurement where that comes from. But I'm just curious how many people are fighting that right now or in the middle of that.
I have an answer. It actually held up one of my projects. It was a software agreement, and that we're a year behind due to that.
Yeah.
But fortunately, we were able to come to terms, and that worked out well, but it did put us a year behind.
But all you have to do is attach a VPAT. It doesn't have to meet any standards?
This one had to meet standards.
Yes.
And
okay.
the standards were not feasible with the type of product that it is.
Which is, yeah.
Yeah, for us, we hired a person. This person's job is to just address the accessibility issues. And so what we've done is for things that aren't quite compliant, we've supplied our testing schedule when we expect to complete.
To be compliant.
To be compliant, that's right.
We seem to be getting a lot more requests for accessibility with VPATs. It seems to be, a very common trend now.
From state institutions mostly?
All over.
All,
Yeah.
okay.
Luckily I have a great team that kind of works and makes sure that the accessibility matches that VPAT. But I usually rely that feedback over to our team as well.
Thank you. Other questions? Our last question was a doozy, and I don't know if, we had the communication path. I don't know if do we want to skip to KPIs?
Oh, let's leave that one off.
Oh, okay. There's a whole, do you feel marginalized by your institution with the new workflows and if they've implemented new systems?
Do you want us to address that, or which?
Or if anyone else wants to, although we are being recorded, so I don't know how comfortable people feel. We had the, oh, it's another one.
Yeah, just regarding the clear communication. For us, it's so helpful when we get, the red lines and we get the tracking. We get communication from our customers that's clear why changes are being made, because we really rely on multiple people to kind of handle that. I'm not a lawyer, and so I use my legal team to address those legalese type of things. So when there's a bunch of changes in the agreement, seeing why and seeing those changes really helps speed up that process. So that's what I have for communication.
Yeah, I think this is maybe more of a personal thing, but a component, I think a critical component of communication is setting expectations. Setting expectations with the library of what they can expect from, your license agreement or your online T's and C's. And similarly, as I mentioned a few minutes ago, to have that same kind of expectation set from the library to the publisher or content provider. So we know, we can alert the attorneys, hey, look, I shouldn't mention any states, but there are some states that have, a lot of paperwork that are involved. So the earlier you can get that to set your reps' expectations, because that they have a whole infrastructure behind them, legal counsel and contracts that they need to get that stuff too. So letting my department know, hey, here's something from state of X, and how that goes. We've dealt with that in past years, and then they can allocate the appropriate internal resources to get that going, prep internally to expect that.
Oh, go ahead.
I'm sorry, jump in again. Again, kind of speaking towards Ken's points, is also communicate if something is needed for this one particular time, or if it's needed for all agreements, because something that we've been trying to do is use our CRM to add notes for our customers so that it speeds up the process. I know that I worked specifically with you, Rachel, because we do need that third signature, which is, it's different for some customers. So that helps me kind of prep that license to give to, our customer the way that they need it, instead of kind of going back and forth and back and forth. So if you're just be honest and upfront, saying like, hey, I'm gonna need this, every single agreement, all this work that we've done for this amendment, please make sure it's in there in the next time. So that helps me.
Yeah. Oh, we have a question. Come on up.
First off, thank you for doing this. This is awesome and great. All of the discussion seems to be about like requirement and what's needed. I'm wondering, how do negotiating principles, the published negotiating principles that aren't necessarily required, but how are they playing into this? And I'm just kind of curious.
Give us an example.
Like Iowa State just got through publishing the negotiating principles, which I'm a big fan of. And I know some other institutions are doing that in terms of, we believe, it should be open, transparent, open publishing, various things. When it's not a state requirement, but it's a principle, how does that, I'm just kind of curious how that plays into it.
Go ahead, Rachel.
Okay. I might be off the mark here, but I'm gonna punt. So recently I saw a thread on the ERL listserv about vendor relationships with libraries, and some libraries have essentially, I think it was University of North Texas that had a manifesto about the relations, their expectations in terms of are cold calls permitted, transparency about pricing and things like that. Is that kind of what you're referring to, like within the contracting context?
Yes, I'm just curious, how does that affect?
I think it's a great idea.
So it's not affecting us as much as I think it should yet. I'm working on redrafting our supplemental addendum that we ask vendors to look at and consider appending to agreements. But my ideas, the like, this would be great and this would be wonderful and like magical unicorns will, this agreement will be beautiful and meet all of our like my moral obligations to our users. But I don't know if our general counsel will accept it. So it's like that.
Why? And
I can let you know.
Because, I'm thinking more in terms of, not the addendum, which we all have, but as you said, the published online, because it needs to go through general counsel, then how does vendors look at that? Is that taken with the same weight as the addendum? Okay, that's nice, we don't care. I'm just kind of curious how that plays into it, if that makes sense, but that's exactly what we're going to.
I think for us right now, they're there in ideals, but they might be quick to fall by the wayside, unfortunately. If it's like a negotiation point, I can give up to get something that's actually required, and that's horrible to maybe admit in a public forum. But it's like, how much can we get to make this a successful negotiation? It's sort of baby steps, where like for my work right now.
I think just the comment from our perspective is that we try to be as transparent as we can. Being a nonprofit, all of our fees are on the website, and from an individual library type scenario where you're interested in a particular piece of content on JSTOR or Portico for that matter, we have about sites, and we hire web developers and people to do that. So I would encourage you to, not that you can't call me, but you can always go to the website, because we try to put as much of that on there as we possibly can. And I think that's also an element of the T's and C's. We really want to be as transparent as we can. I think when we get into more consortial type, where there's more of a negotiation, where it depends on how many institutions are participating in a particular order, that's where things can be a little less transparent. But for the most part, all of our stuff's on the web.
Yeah, and just kind of we make sure that everything's on the web as well.
Are there any other questions? I don't see anyone's hands up.
Are we doing on time?
I think we have about 3 minutes left. So I will just skip over the other ones and say thank you very much for joining us today and sharing some of the things that are happening at your institutions and asking questions. And I also would like to say thanks to all who participated, and please remember to complete the post-conference survey. All right. Thank you. I hope you enjoy the rest of your conference.